Okay, so if people online, you guys can hear us, no problem. If someone could just either unmute yourselves and tell me or put it in the chat. I'm seeing some thumbs up. So yes, thank you everyone for responding.
Yeah, McLaughlin can hear us.
Give me 1 second. I'm just going to shut the doors and we're going to get going here.
I can get this one.
Okay, so welcome everyone to our latest installment of the Lunch and Learn program. Today we have Gary Robinson here to give you a talk on judicial interim release and the latest developments. To give you a little bit of background about Gary, he got his call in 1997. He's been with Legal Aid since 2001. He started out as a staff lawyer up in Thompson, Manitoba, came down to Winnipeg in 2012. In 2019, he became the area director for the northern regions, specifically the PAW. He also is the, I think it's since 2012, was it, the supervising attorney of the Winnipeg Duty Council office, which incorporates both the Criminal Bail Duty Council office as well as the Child Protection office. With that, I'm going to just pass you on to Gary if there's anything else you wish to say about yourself. And Gary will let you know what's going on in the world of bails.
Yeah. Yeah, no, that's me. Been with Legal Aid since pretty much articling, off and on as a contract lawyer, and then got hired on in 2001, and I wouldn't want to be anywhere else. Oh, somebody's at the door.
Thank you. Hello. Hello. Sorry I'm late. I was in a client meeting.
Okay. I should know your
Articling at Agassiz.
Okay.
Yes.
Okay. I guess I saw you during the articling orientation.
That's right. Yes.
All right. Okay. I was going to talk about judicial interim release, recent developments. If that's all I talked about, this would be about a 5 or 10 minute chat, because I can go through the criminal code and tell you a little bit about the sections that are new. So I'll end up doing that, but I just thought I would give you a little bit of bail history, just to maybe help provide a little bit of context about judicial interim release. I was at the summer program in Vancouver, and one of the lecturers mentioned that in 2014, approximately 54% of persons in custody are waiting for their case to be heard. So they're on remand. They may not have even gone for bail, or they've been denied bail, and they're waiting for their trial or their disposition of their case. And that was in 2014, 54% and then now in 2021, 2022, more recent statistics say it's over 70%. So 70% of incarcerated persons are just waiting without bail. They couldn't get bail denied or whatever. And so 70% of them haven't been sentenced, just waiting for their case to be heard. And, recently in the news, we're told that the bail system is broken. Everybody's getting out too easily. It just doesn't add up, doesn't make a lot of sense. People who are not released can sit for weeks and months and sometimes years waiting for their case. They, of course, lose their housing in many cases. They have family problems. Their family relationships fall apart. Their job history is messed up. And as well, it's a little more difficult to defend themselves when they're in custody rather than out and more able to access their lawyer and work or money to pay their lawyer and that sort of thing. And so there's a lot of pressure on these people to just plead out and get it over with, and maybe tell their lawyer, I didn't do it, but I'm pleading out just to get this over with, give me time served, give me a short shot or whatever it is. But so I imagine there's a lot of pressure on a lot of people to plead out when perhaps their case might result in an acquittal or something other than a guilty plea or a conviction. So that's a concern that like what are these people going to do when they can't get bail and they have 18 months or 3 years to have their case heard according to Jordan guidelines. And then recently in the news, for anybody who reads the Free Press still, there's lots of articles about bail reform. And of course, the tone of those articles is it needs to be tougher. Too many people are causing problems in the community. People are being released who are dangerous, committing more offenses. And of course, it's true. But these bad cases then just lead to more incarceration rates. They don't look at the statistics. They don't provide statistics and tell us what the real risks are and what the real dangers are and what alternatives there are. It's just basically an easy way to get political points. If you're in opposition, you blame it all on whoever's in power, that they're not doing anything, they're not taking it seriously. And of course, if we were in power, we would solve all these problems. Some of the high profile cases in the news recently include human smuggling, gang extortions, which seems to be a new thing. Carjacking isn't a new thing, but they make it sound like it's a new thing. And people committing multiple violent acts while out on bail. For example, that fellow from Saskatchewan. Those things are brought up over and over again. So there's a lot of pressure, a lot of political pressure, a lot of grassroots pressure to crack down on bail. I'm going to give you a little bit of history. Bail in the common law tradition sort of goes back to Magna Carta, but Magna Carta only referred to landowners, landholders, and nobles. So only free men, as they were called, were covered by Magna Carta. But it did say that no free man shall be seized or imprisoned except by lawful judgment or the law of the land. So it wasn't a very fulsome bail section, but they did at least put that in that early legislation, which applied to a small percentage of the actual people of England. Moving forward a bit, the English brought more bail laws in 1679. The English Habeas Corpus Act, which was what they used to call bail in those days. We still have habeas corpus today, but it's used a little bit differently. 1689, they had the English Bill of Rights, which talked about limiting arbitrary detention and entrenched the right to reasonable bail. And of course, colonial Canada around that time mirrored English rules. Justices of the peace could grant bail except for the most serious of felonies, in which case you would need a judge or sometimes two judges to consider that, which interestingly is very similar to today. We still limit bail for homicides and some more serious offenses to King's Bench, the Superior Court. In 1869 in Canada, they actually did legislate pre-trial release as the norm, detention as the exception. It wasn't quite codified until 1892 when Canada adopted the criminal code and then formally codified bail. I actually went and I dug up the code from 1892 just to see what it said. Section 601 said, reflected the presumption of release, but with discretion of judges to deny bail for serious risk factors such as flight. But it was also expensive to get bail. There was cash sureties, recognizances were pretty standard. So the vagrants and the people without means would have had a hard time getting bail back in 1892. And in those days, the number one concern for bail was ensuring the attendance at trial of the accused person. That was numero uno up until quite recently. Public safety was mentioned, but it was pretty much dealt with as a attendance issue. So if you had someone you thought was super dangerous, you would just say, well, you're not going to get bail because we don't think you're going to show up in your trial or that sort of thing. So everything was couched on attendance in court. And life was much simpler then. Finally, we move into the modern era, 50s and 60s. There was a growing concern over the overuse of pretrial detention, financial barriers for people who can't get surety or cash bail. 1969, the We Met report criticized the bail system as unjust and inefficient. And then in 1972, we got the Bail Reform Act, which fundamentally changed Canadian bail. It codified the presumption of release without conditions. And I actually went and I took a look at the sections in the criminal code from 1972 as well. And if I was a little more on the ball, I would have presented that as a slide for you all to look at, but take my word for it. There was no reverse onus provisions at all in the 1972 criminal code for bail. They did talk about the ladder principle. So release on the least onerous form possible. So the ladder principle still exists today. You work your way up as necessity rises. They mentioned they also added in public safety as a consideration and public interest as potential grounds for detention. So this 1972 bail looked similar to what we have today, except for all the amendments that have occurred in the last 50 some odd years. Also, the 1972 Bail Reform Act gave police more power to release people. So the idea was, I guess, the jails were overflowing, and they needed to find ways to reduce the overpopulation of jail and to reduce court backlogs. And in 1982, the charter guaranteed the right to bail, not to be denied reasonable bail without just cause, and protection against arbitrary detention. Section 9 of the charter, bail is the rule, detention the exception. Finally, reverse onuses did start to appear in 1975, so not long after the original Bail Reform Act. That's when we start seeing reverse onuses. So originally, well, not originally, but since 1972, the accused was to be released unless the Crown showed cause in every situation. Or the Crown could show cause as to why certain conditions should be imposed. And then in 1975, they added some reverse onus conditions. So if somebody was already out on bail, commits another indictable offense while on release, well, now it's a reverse onus. If they're not a Canadian resident, that would be a reverse onus situation. And then drug trafficking, importing, and exporting became a reverse onus as well. So those were the first three reverse onus The Supreme Court said, yeah, that's okay, in 1992. It took a while for them to challenge some of that stuff. But drug trafficking was very narrow, limited, and they felt that that was a reasonable way of adding in reverse onus. I forgot to mention this, but the public interest condition that was added in 1972 was thrown out by the Supreme Court. It was too vague because of the public interest. Of course, they figured they fixed that later on, but took a while for Parliament to come up with that. Now we can fast forward to 2019 with Bill C-75. So there was a little bit of a gap. There were amendments along the way, but I think the big one came up in 2019, and this is something that exists in our code today. Best part of that, I think, is what they call the principles of restraint. So this was in answer to many Indigenous persons being taken into custody and or vulnerable populations. So in 2019, they brought in section 493.1, 493.2 to call the principle of restraint, telling police and judges that primary consideration should be the operation or modus operandi, I guess, that the police should be following. And then 493.2 refers to Aboriginal accused or vulnerable populations. So this is something that they never had to consider before formally, but perhaps informally. Now they have to say we have an Indigenous person in custody. This is a special group that we need to give extra consideration to. And then this follows through into bail court with judges. So there was an attempt at that time to deal with overrepresentation of Indigenous persons, systemic discrimination. And it also simplified police release. I won't refer to the section, but it made it a little bit easier for police to release. And that was rather good timing because 2020 COVID came along and there was a big emergency. The courts tried their best to avoid people going into custody, just to try and cut down on transmission rates in remand center and on various jails at the time. And so they used it was very interesting. There was a lot of people being released that normally would have been released, and just to avoid the infection rate. Also, we started to use justices of the peace, so section 503 bails, which we call detention reviews, which takes place after the police arrest someone. So the police arrest somebody and they're opposed to release. They don't take them straight to the remand center or the PAW or correctional or whatever. They now have to go to a justice of the peace. Well, that's not new. They always had to do that, and before they could get a remand order for somebody to go into custody. In 2020, after some of those police powers had been made simpler, the Crown attorneys and legal aid in Manitoba came up with a 24-hour system of detention reviews. The JJPs refused to work from 11 p.m. to 7 a.m., but probably for the best. But the Crown attorneys and legal aid staff lawyers and private bar lawyers on contract covered those shifts. And so anytime the police were supposed to release, they would send their police report to the Crown. The Crown would then contact whoever's on shift for legal aid, and then potentially do a bail. So not in front of the judge, but with the justice of the peace. Rarely contested, but that was allowed. You could do a contested bail anytime you want, 7 a.m. till 11 p.m., 7 days a week. Or you get a consent release if you can work out something with the Crown. And you would have the police reports ahead of time, which was very efficient. So that became a thing in 2020. And then after courts were reopened again, and we all started going back to court, and they let people go back into the remand center, the incarceration rates, of course, went up through the roof again, and we all started doing bails in person with judges. But that Section 503 detention system, review system continues. It really helps. It cuts down on a small percentage of people going into custody. So it's been maintained. Let's see. The other thing that happened in 2019 was the addition of one of the reverse onus conditions with respect to domestic violence. So that was added. There was a concern about domestic violence. So somebody said anybody who has a history with a record of domestic violence and they now have a new charge, it's a reverse onus. So even though they may not be pending or on bail or serving, well, if they're serving probation, yeah. But if they're not before the courts for anything else, they've dealt with whatever they've dealt with, but there has been a previous domestic violence incident with any partner, it could be the same one or a new one, then that's now a reverse onus. So that's one of the new reverse onus provisions. And then the most recent bail reform in 2024 was they added B.2, 6B.2. So now it's a reverse onus for anybody who has previous violent offenses within 5 years. So anyone who had a violent offense within the last 5 years of the day that they get a new charge, now that's a reverse onus. So they're going to go straight into custody, and it's up to the accused to raise the onus, prove that they are that they can be released. So that was another new reverse onus. So you can see there's sort of a pattern here. Every time something goes to Parliament and there's a new problem, it goes to reverse onus, it seems like. And they make judges give written reasons why they release somebody sometimes. That they have to think about what they've done, I guess. So that was the last bail reform, which was came to force January 4th, 2024. It also added more firearm offenses. So we went from 0 reverse onus conditions in 1972 to, I don't know, about 20 or 30 reverse onus exceptions now. I won't go through all of those. And then finally, in the news, the government is talking about another bail. I guess this is in the works now. We'll probably see what that looks like. The government paper I looked at yesterday said that they're going to go after violent and repeat offenders. They're going to make it more difficult for people charged with serious crimes, violent auto theft, break-and enters, human trafficking, violent assault, sexual assault, extortion. And so it's pretty much a mirroring of what the conservatives call the Jail Not Bail Act. The other thing that the conservatives are seeking, I'm not sure if that'll make it through or not, is to repeal the principle of restraint. So Section 493 that said that there needed to be consideration for individuals. They're talking about repealing those sections and create a major offenses category. So, and then anybody facing a major offenses category would be a reverse onus. In any event, so I'm sure that 70% will not be reduced anytime soon of people awaiting in custody for their cases to be heard. And that is the summary. That is it. There was other legislation that they were talking about last night, which was the Intoxicated Persons Detention Act to be expanded to 3 days. So, but anyway, not this topic for today. Anyway, so I've gone through the sort of recent bail changes in the criminal code. In a couple of months, we'll see some more, I'm sure. The original 1972 Bail Reform Act has not changed too much in its sort of format, but a lot of reverse onus has been added over the last 50 years. And I don't know, the pendulum doesn't seem to be reverting, swinging back anytime soon. I suppose it swung back a little bit when they brought in the principles of restraint and when they increased the police powers to release. But anyway, it's going back the other way for the next foreseeable future. Those are my comments. I didn't think I would be able to fill a whole hour with.
Does anybody online have any questions for Gary or in person?
Therese does.
Hello, Therese.
I thought I was on mute. I'm sorry if you could hear me typing.
Oh, no, you were on mute. Or very quiet.
Gary, what are the proposals for alternatives to detention, given that the cost of keeping people in custody is so expensive? Besides, I guess, the traditional kinds of things like reporting conditions or treatment center, is there discussion about, say, ankle bracelets for monitoring where people are at certain times, or
Well, they did bring in. Oh, sorry. They did bring in ankle monitors last year.
Is that for bail?
Yeah, it's for bail, and so that helps people who can't come up with cash or sureties, and it's. I suppose that's an alternative to jail while on bail. I don't think they use them for probation or conditional sentences. I think it's strictly a bail issue. As far as alternatives to jail, I don't know what. I'm not sure what's coming down the pike. They're actually going to be cutting back on some of the things that a conditional sentence would include. So they're going to be. And originally conditional sentences could have been for anything when that came out in 97 or whenever it was. And that got whittled down to nonviolent offenses pretty much. And then recently it was expanded to allow for violent offenses, but now I think it's going to be cut back again. So there's this constant tension between the courts and parliament and prosecutions and defense. And I guess that's what keeps us going, but I don't know how they plan to fix society with all the, well, unless their solution to that is to lock people up for 3 days and get them treatment for their meth addiction or whatever it is, fentanyl or whatever. I mean, the drugs that they were using when we were young lawyers didn't seem to have the same impact as the drugs they use now.
Yeah, for sure.
Does anyone else have any questions for Gary? No? Okay. Okay, well, thank you, Gary, for that enlightening discussion. There's going to be a lot of changes on the horizon, as Gary said. So it's going to be up to each of us to make sure that we're aware of changes in the law in the next little while. We know they're coming. We'll have to see what they're going to look like. I just wanted to also make sure everyone knows, I sent around an email a while ago. We've gotten our Lunch and Learn folder fixed on our homepage. So all the Lunch and Learns that we've previously done in this last year are now uploaded. So oh, sorry, Trace, if you can mute yourself.
Yeah. Sorry about that.
No problem. So we have on that list so far self-defense and provocation, how to do a criminal disposition. There's the 2 parts from the Lawyer Strong presentations. We have developments in youth law and criminal contempt. And as well, the science of firearms was the last one. We should very soon have this presentation as well uploaded. And we hope that all future Lunch and Learns will be recorded and uploaded so they're available for everyone. So if you're looking for them, I sent around the link as to where to find them. If you can't find them, just go into our main page, and in the top right-hand corner, there's a little search box. If you just type in the word Lunch and Learn, it'll bring you to that. And then you can access the link to any of those presentations that we've previously had or any future presentations. So if anyone has any questions or any difficulties with it, just feel free to reach out to me. I'm Catherine, in case anyone doesn't know, and I will make sure that we can get you attached to whatever it is you need. Okay, thanks everyone. Appreciate you coming today. Have a great weekend.
Thanks, Gary. It was interesting.
Thanks.
Now we can go off the record.